Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack's at Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish or Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculousness that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. Not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Welcome back. Welcome back. Today is still Tuesday, August 12th of 2025. And boy, have we been waiting for this. We've been waiting for this motion for a long time. And it was originally filed. The notice of motion in the Karen Reed civil case was filed all the way back on July 9th, but we could not get a hold of the papers. We couldn't get the papers. Because in Massachusetts, you can't get the papers until all the papers are in. And all the papers are in. And so now we get to look at the papers. And this is in the case of Paul O'Keefe against Karen Reed, the Waterfall, and C.F. McCarthy's. It's going to be a cold read. These are so hot off the press right now. You guys are on the cutting edge. You are on the cutting edge. So we'll give everybody a chance to come in so they could all hear the papers too. Thanks, Bridget, for your super sticker. Thank you. You made mistakes in your email. If you know, it says this is no longer an episode. This is a series. It is. And there's going to be some spinoffs too. This is just one of the spinoffs. This is the O'Keefe's versus Karen Reed wrongful death case for a car accident that didn't even happen. It's crazy, I know. And I told you that in the other, I've done a couple streams, I think, on this case. I told you that from the beginning, that I thought it was going to be tough. Because there's never been a motor vehicle accident report filed, to my knowledge. And we have so many insurance adjusters that watch the show who are with auto insurance companies or liability insurance companies. And all of you have said to me, you would never pay on this claim because there's no motor vehicle accident report or fatality report that is required to be filed within however many days with the RMV in Massachusetts. In New York, I'm not sure how many days you have anymore because everything is all melting together in my brain. And we call it the DMV here. So thank you. You made mistakes in your email for gifting 5 memberships. You're so generous. Welcome to all the new members. And Natalie also became a new member. So welcome to all of you. Without any further ado, let's look at the papers. First up, docket number 37, if you guys are keeping track, docket number 37. And this is in Plymouth County because that is where Paul O'Keefe lives or lived at the time that it was filed. And you have your choice of venue in a civil case. You can choose where you bring your case. And typically, I'll tell you about New York, and I'm sure that Massachusetts probably is relatively the same. It can be where the plaintiff lives, where the defendant lives, where the corporation is headquartered if you're suing a corporation. There are some exceptions to that rule, but in this case, they chose Plymouth County because that is where Paul O'Keefe lived at the time. I think now he lives in Canton. I'm not sure. That's what it said on the witness list, or the witless list that we looked at in the Karen Reed second trial. And this is the caption of this case is Paul O'Keefe as personal representative of the estate of John Joseph O'Keefe III. Paul O'Keefe individually, John O'Keefe II, that's John's father. Margaret O'Keefe, that is AKA Peggy, and Margaret O'Keefe as grandparent / guardian of Kaylee Furbush. It is the niece. Plaintiffs versus CNC Hospitality LLC DBA, doing business as CF McCarthy's. GNS Hospitality LLC, doing business as CF McCarthy's. Waterfall Bar and Grill Limited, DBA, Waterfall Bar and Grill, and Karen Reed. This is defending Karen Reed's motion to dismiss the plaintiff's complaint pursuant to Massachusetts Rule of Civil Procedure 12B6. Buckle up, buttercups. Got to get my red pen. Wait, can I highlight on this document? Sometimes you can highlight on them and sometimes you can't. So I don't know. People are telling me about PDF converters and all that. Come on, you think I have a time to learn new tricks? I have no time to learn new tricks. But a girl does love her red pen, and that's me. And I love my red pen. Defending Karen Reed's motion to dismiss the plaintiff's complaint. Now comes the defendant, Karen Reed, who respectfully requests this honorable court dismiss counts 10, 11, 12, and 13 of the plaintiff's complaint pursuant to Massachusetts Rule of Criminal Procedure 12B6 for failure to state a claim upon which relief can be granted. There are a few things that I like more than saying, I told you so. And I called this out from the beginning. As a matter of law, the plaintiffs have not, nor can they present a claim that they have suffered emotional distress, and as such, these claims should be dismissed. In further support hereof, the defendant repeats and incorporates herein the memorandum of law in support of the defendant, Karen Reed's motion to dismiss the plaintiff's complaint pursuant to Civil Rule 12B6 filed in conjunction with this motion. Wherefore, Karen Reed respectfully requests that this honorable court allow this motion and dismiss counts 10, 11, 12, and 13. And if you're asking me what those counts are, we will look at them, I'm sure, because they will be more fully set forth in the memorandum attached here to XOXO, Karen Reed by her attorneys, William Kevel, Christopher George, Marissa Palladini of Mellick and Porter in Boston, dated July 9th. But remember, we couldn't get a hold of the papers till just now. So hold on while I remove that and then bring up the next the memorandum so we can get a better idea of what they want to dismiss and why. And here it is. This is docket number 38. Docket number 38 in the Paul O'Keefe versus Karen Reed et al. And others. This is only 12 pages. Wow. Okay. Light reading today. A little light reading. Memorandum of law in support of defendant Karen Reed's motion to dismiss the plaintiff's complaint pursuant to Massachusetts Rule of Civil Procedure 12B6. Introduction. Defendant Karen Reed hereby files the within memorandum of law in support of the motion to dismiss counts 10, 11, 12, and 13 of the plaintiff's complaint pursuant to Massachusetts Rule of Civil Procedure 12B6. The counts sought to be dismissed are as follows. Count 10, Margaret O'Keefe versus Karen Reed, negligent and or reckless infliction of emotional distress. Count 11, John O'Keefe Sr., we'll just call him, that's Mr. O'Keefe, John's dad, negligent and or reckless infliction of emotional distress. Count 12, Paul O'Keefe versus Karen Reed, negligent and or reckless infliction of emotional distress. And count 13, Kaylee versus Karen Reed, negligent, reckless, and or intentional infliction of emotional distress. I've said from the beginning that I thought that these emotional distress claims were tenuous. We'll see what the court does with them, and we will see what the defense attorneys say the law in Massachusetts is with regard to proving an emotional distress claim. And here we go. I don't need any pickle juice. Ew. No, 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 no. As a matter of law, the plaintiffs have not, nor can they state a claim upon which relief can be granted insofar as 1, any distress claims are subsumed by the wrongful death statute, GL 229, Section 2. None of the plaintiffs can recover for negligent infliction of emotional distress based upon the occurrence of the alleged accident because they were not at the scene, nor did they witness the immediate consequences to the decedent. Number 3, the allegations in the complaint concerning the circumstances of the alleged accident and the defendant's purported statements and actions in the hours after the alleged accident cannot support a claim of intentional or reckless infliction of emotional distress. Accordingly, and for the foregoing reasons, counts 10, 11, 12, and 13 of the plaintiff's complaint should be dismissed pursuant to Rule 12b-6. Ding, 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 ding. See, look, Wilma's paying attention. Wilma says, I believe you have mentioned on other occasions that there are no grounds for this. I did. Why aren't they filing against the homeowner? It happened at their home. Kristen wants to know. Well, give you a couple of reasons. Number 1, there's no cause of action for a car accident that happens in front of someone's house, if indeed that car accident did happen. Number 2, a premises liability case in the event of, let's say, perhaps the dog attacked John O'Keefe. Then in that case, they would have a case against the homeowner and the owner of the dog. But the O'Keefes refuse to believe that that is what happened. And they are refusing to sue who are now their friends, in my opinion. And statute of limitations is up on that anyway now. So they wouldn't be able to file it now. But of course, they think these people are their friends and they didn't want to sue them. However, I think in their best interest, it might have been prudent to do that. I do not know if, and I had said this from the beginning, that it would have been if I was a defense attorney in this case, I would have third-partied in the homeowners, because the defense here is going to be the car accident did not happen. Something else happened in the house. And plus, we want depositions of all those people, which I think they're going to get anyway. That's right. And in conclusion, Karen Reed did not hit John O'Keefe, and John O'Keefe was not hit by a car. Thank you for your time. Thank you, dog treats. You will not hear any of the depositions, actually, Tina. You won't hear any of the civil depositions are not public. They're not televised. They will never be released. And the only way you'll ever see any portion is if it's attached to a motion. And even in that case, it may be redacted or impounded but if there's a trial, you can bet that every single news organization in Massachusetts will be clamoring to get a camera in that courtroom. So don't worry. We'll see what happens. Roman 2, relevant allegations in the plaintiff's complaint. The following allegations are taken from the plaintiff's complaint and are presented here in a light most favorable to the plaintiffs pursuant to the legal standard. They should not be misconstrued as admissions by the defendant. The defendant vehemently denies that she is liable to the plaintiffs, as there was no collision between the defendant's SUV and John O'Keefe III, leading to his injury or death. Plaintiffs allege that on January 29th of 2022, between approximately 12:11 and 12:36 a.m. at 34 Fairview Road, Canton, Massachusetts, the defendant drove her SUV and hit the defendant, John O'Keefe III, decedent, while under the influence of alcohol. See Exhibit A, the complaint. The plaintiffs allege that the decedent was knocked down to the ground in front of 34 Fairview Road, suffered serious injury, and died. The plaintiffs claim the defendants then fled the scene and returned to the decedent's residence at 1 Meadows Ave. Plaintiffs further allege, give me 1 second. Plaintiffs further allege that at approximately 4:30 a.m., the decedent the defendant woke up the decedent's 14-year-old niece, Kaylee, talked about decedent's death and hitting the decedent with her SUV, and involved Kaylee in her frantic calls about the decedent's death. Plaintiffs claim that the defendant made telephone calls in Kaylee's presence, during which the defendant commented, quote, "Maybe I did something. Maybe a snowplow hit him. Maybe I hit him." I'm going to break from the document to say that we have said several times that I was of the opinion that I thought it was in very poor form to force the niece and nephew of John O'Keefe to testify at the trial and the criminal trial. In trial number 1, both the niece and the nephew were compelled to testify. They were forced to testify. The cameras were turned off. And the reporters were allowed to report on their testimony, but it could not be recorded in any way. In trial number 2, only the niece testified. And it was my opinion that I did not think it was worth it. The trauma that it causes the children to testify against a woman, Karen Reed, who's on trial for murder, who was facing life in prison, and who, by all accounts, was very generous to these children and loved them very much. She homeschooled them, I think, during the panty. She bought them things, clothes and food, and she spoiled them. And that's one of the things that John O'Keefe and Karen Reed argued about. In my opinion, it was in poor form to call them to the stand. I thought that the long-term effects of having done so is going to affect them for a very long time. And I still stand by that. But now you can see why the family wanted the niece to testify, because they wanted it on record under oath that this is what the niece said happened. And because of that, she's entitled to money on an emotional damages claim, which I said was tenuous from the beginning. I didn't think it was worth it to risk it, but they did it anyway. Plaintiffs allege that on or about 6:03 a.m. on January 29th of 2022, the defendant observed the decedent laying in the ground, buried in the snow at 34 Fairview Road in Canton. At or about 7:50 a.m., the decedent was formally pronounced dead at the hospital. At or about 7:50 a.m., hours after 7:50 a.m., the plaintiffs claim the defendant appeared at the decedent's home, feigned comfort to his family, removed her vehicle, and/or destroyed relevant evidence. They further allege the defendant knowingly and deliberately changed her story and fabricated a conspiracy, knowing the same to be false. That is also alleged in the complaint. The complaint alleges that Margaret O'Keefe is the decedent's mother, John O'Keefe II is the decedent's father, Paul O'Keefe is the decedent's brother, and Kaylee is the decedent's niece. Margaret O'Keefe, John O'Keefe, and Paul O'Keefe claim that they came upon the decedent's body at the hospital. All the plaintiffs allege that the defendant created a false narrative. Roman 3. Standard of review. Hold on a second. Because nobody needs anything from me until I'm on the air. So give me one sec. Hold on. Hold, please. Standard of review. Massachusetts Rule of Civil Procedure 12b6 provides that a defendant may move to dismiss a complaint if it fails to state a claim upon which relief can be granted. In evaluating the legal sufficiency of a complaint under Rule 12, the court must accept as true all of the factual allegations in the complaint and draw all reasonable inferences from it in favor of the plaintiff. Nevertheless, the court need not accept as true any legal conclusions that are presented under the guise of being factual allegations. To survive a motion to dismiss, a complaint must contain factual allegations which, if true, raise a right to relief above the speculative level and are not simply consistent with an entitlement to relief. Additionally, a complaint must contain more than labels and conclusions, and a formulaic recitation of the elements of a cause of action will not do. Citing several cases. Roman 4, argument. Margaret and John O'Keefe II's distress claims are subsumed by the wrongful death statute, General Law 229, Section 2. The complaint does not identify that the decedent passed with a spouse or child, meaning the persons entitled to any wrongful death damages are the next of kin. Pursuant to General Law 190B, Section 2103, the next of kin are the decedent's parents, Plaintiff Margaret O'Keefe and John O'Keefe. With respect to claims that may be asserted on behalf of the decedent's parents as the next of kin, General Law 229, sub 2 states in part, quote, a person who, one, by his negligence causes the death of a person shall be liable in damages in the amount of, one, the fair monetary value of the decedent to the person entitled to receive the damages recovered as provided in Section 1, including but not limited to compensation for the services, protection, care, assistance, society, companionship, comfort, guidance, counsel, and advice of the decedent to the persons entitled to the damages recovered. Here, plaintiffs allege Margaret O'Keefe and John O'Keefe II allegedly experienced an emotional reaction caused by the death of their son. As the next of kin, their claims for loss of consortium are factored into the decedent's estate's wrongful death claim and may not be duplicated as part of any claim for emotional distress. See Stonehill College versus Massachusetts Commission Against Discrimination. Emotional distress existing from circumstances other than the actions of the respondent or from a condition existing prior to the unlawful act is not compensable. The complaint fails to distinguish or otherwise delineate the alleged harms caused to Margaret O'Keefe and John O'Keefe II between loss of consortium and other emotional distress. Count 10 and 11 of the complaint should thus be dismissed. See Exhibit A, alleging that the plaintiff suffered aggravated emotional distress. And paragraph 132, alleging defendant's negligence caused their son's death as the basis for emotional distress claims. B, the plaintiff's emotional distress claims fail as a matter of law. The complaint titles counts 10, 11, and 12 negligent and or reckless infliction of emotional distress without providing context for what conduct within each count applies to what claim. The elements of reckless infliction of emotional distress are markedly different from that of negligent infliction of emotional distress because reckless infliction of emotional distress contains the same elements as those for intentional infliction of emotional distress. To prevail in a claim for the intentional infliction of emotional distress, the plaintiffs must prove, number one, that the actor intended to inflict emotional distress, or that he knew or should have known that emotional distress was the likely result of his conduct. Number two, that the conduct was extreme and outrageous, was beyond all possible bounds of decency, and was utterly intolerable in a civilized community. Three, that the actions of the defendant were the cause of the plaintiff's distress. And four, but the emotional distress sustained by the plaintiff was severe and of a nature that no reasonable man could be expected to endure it. To prevail in a claim for the negligent infliction of emotional distress, the plaintiffs must prove 1, negligence, 2, emotional distress, 3, causation, 4, physical harm manifested by objective symptomology, and 5, that a reasonable person would have suffered emotional distress under the circumstances of the case. The complaint's failure to specify the factual allegation in support of the different emotional distress claims warrant dismissal, or at the very least, a more definite statement pursuant to Rule 12E. That argument aside, counts 10, 11, and 12 appear to claim reckless infliction of emotional distress based on the defendant's alleged formation of a false memory, and the negligent infliction of emotional distress based on certain plaintiff's observations of the decedent's body in the hospital after 7:50 a.m. on January 29th, 2022. Set forth below, the complaint fails to present a cognizable claim for emotional distress. Number 1, the plaintiffs cannot present a claim for negligent infliction of emotional distress because their claimed distress was not contemporaneous with the alleged accident. No plaintiff directly witnessed the defendant's alleged negligent. No plaintiff directly witnessed the defendant's alleged negligent conduct. The alleged vehicle strike that is claimed to have occurred between 12:11 a.m. and 12:36 a.m. on January 29th of 2022, or the decedent himself until at least 7 hours after the incident. Massachusetts recognizes claims for emotional injuries by parents and close relatives arising out of their witnessing an accident to a loved one, but the plaintiffs must show A, substantially contemporaneous knowledge of the outrageous conduct, and B, a severe emotional response. Quote, citing Nancy P. v. D'Amato, quote, only a bystander plaintiff who is closely related to a third person directly injured by a defendant's tortious conduct and suffers emotional injuries as the result of witnessing the accident or coming upon the third person soon after the accident states a claim for which relief may be granted. Okay, I'm going to go back to law school for a second. I'm going to give you an example. An example would be, and I think there was a very tragic accident that happened very similar to this in California recently. Let's say a mother is walking in a crosswalk with her children, pushing a stroller. And let's say a person is drunk driving, flying down the highway at an excessive rate of speed and crashes into the baby stroller and the 2 children and not the mother, and the mother witnesses the whole thing. That is a very substantial claim under Massachusetts law for the negligent and or intentional infliction of emotional distress, because the mom is there. She's within what they call, I don't even know if they have a zone of danger law in Massachusetts, because now I'm really pulling out a law school torts class. Within the zone of danger, some states have that law where you have to be within the zone of danger. Like it could have been you that was hit. And that is not what happened here. What happened here is they went to the hospital and they saw his body, and they say that they have been emotionally affected by that. Now, moving on. The close proximity of time between the alleged harmful event and a plaintiff's claim for emotional distress must be near instantaneous. Okay, so that's Massachusetts law. It has to be near instantaneous, where you hear the crash and you come running out and then you see what happened. There's a case called Cohen v. McDonald that says, mother who learned of her son's passing by telephone 7 hours after the event and was not at the scene of the event could not pursue a claim for emotional distress. That's a case from 1983. Here, Margaret, Paul, and John O'Keefe II each allege that sometime after the decedent was transported to the hospital, at least 7 hours after the alleged vehicle strike, based on the factual averments, they observed their adult son or brother's body in the hospital. There is no allegation that any plaintiff observed the alleged vehicle strike itself, or that the plaintiffs were within the vicinity of 34 Fairview Road when it occurred. Moreover, the plaintiff's claimed shock was not experienced immediately after the occurrence, but rather at least 7 hours later, removing it from the scope of requisite temporal proximity. See Migliori. Courts have imposed relational, temporal, and spatial limits on the scope of liability for emotional harm. And Ferreter, shock occurred immediately after the accident. The complaint contains no allegation that the plaintiff, Kaylee, directly observed the alleged conduct that caused the decedent's death, nor did she observe the decedent at any point thereafter. The alleged perception of death, as alleged, was based on conversations with the defendant, and there is no precedent for one to claim emotional distress as a bystander merely by learning via conversation that a loved one has been injured or passed away. Because the complaint fails to present a claim that the plaintiff's claimed emotional reactions occurred contemporaneously with the alleged tortious conduct or immediately after, their negligent infliction of emotional distress claims have no legal basis and should be dismissed. Okay, do you understand? Do you understand that? Should I explain that a little bit better? Okay. They weren't there. They didn't see it. And this is taking their complaint as truth. Even if there was a car accident, they weren't there. They didn't see it. And the shock that they suffered was not brought on or suffered or sustained by them contemporaneous with the event, the alleged car accident. And therefore, under Massachusetts law, those emotional claims cannot stand. 2, the claim for reckless infliction of emotional distress fails because there was no extreme or outrageous conduct directed towards the plaintiff that resulted in severe harm. Plaintiffs each allege that the defendant outrageously created a false narrative, according to the complaint. There are no allegations that the claimed conduct was performed by the defendant with such reckless design to cause emotional suffering to the plaintiffs. The defendant's statements in which she questioned and or denied striking the decedent with her vehicle, allegedly creating a false narrative, or speculated that a snowplow may have struck the decedent, do not rise to the level of intent toward the plaintiffs. Moreover, putting aside that she was successfully defending herself against unproven and false criminal charges pending in the Norfolk Superior Court, the plaintiffs claim that the defendant's conduct after the accident was extreme or outrageous fails as a matter of law. See Poley v. McMahon, finding that allegations of verbal attacks, filing false police reports, and harassment petitions did not rise to the level of extreme or outrageous, and the person bringing suit must show that the petitioning activities lacked any reasonable factual support or arguable basis in law. Liability cannot be predicated on mere insults, indignities, threats, annoyances, petty oppressions, or other trivialities, nor even is it enough that the defendant has acted with an intent which is tortious or even criminal, or that he is intended to inflict emotional distress, or even that his conduct has been characterized by malice or a degree of aggravation which would entitle the plaintiff to punitive damages for another tort. They're saying what happened after she was being accused of having hit John with her car is completely normal, does not rise to the level that is required to sustain a cause of action for reckless infliction of emotional distress, because nothing that she did was extreme or outrageous enough under the law. The complaint contains no factual averment that identifies the substance of the alleged false narrative and how it is outside the bounds of all possible decency and utterly intolerable in a civilized community, such that the plaintiffs may pursue an emotional distress claim. Without requisite factual averments, the complaint fails to present a cognizable claim for reckless infliction of emotional distress. 3. Kaylee's claims for emotional distress fail as a matter of law. Within count 8, the plaintiff, Kaylee, asserts multiple claims for emotional distress, but does not ascribe what conduct applies to what type of claim, i.e., negligent versus reckless versus intentional infliction of emotional distress. Plaintiffs allege that the defendant spoke to a third person on a speakerphone in Kaylee's presence, waking her up in the process, notifying her that something may have happened to the decedent, and inferring that Kaylee perceived the decedent's death. The plaintiffs also allege that the defendant feigned concern for the family, and drove her SUV away from the decedent's residence after the decedent was declared dead. Finally, plaintiffs again allege that defendant created a false narrative. For the reasons previously stated and as set forth below, the complaint fails to state any cognizable claim for emotional distress upon which relief can be granted to Kaylee. Defendant's alleged conduct, as identified in count 13, feigning sincerity and driving her SUV away from the property that the defendant allegedly did not own or control, does not rise to the level of conduct that would be considered so outrageous and is extreme that it would be considered utterly intolerable in a civilized community. Moreover, the defendant's questioning what happened during a phone call with third parties, even if in plaintiff Kaylee's presence, is also not actionable conduct. To the extent the complaint repeats and restates various elements to establish a claim for emotional distress, actual factual averments are necessary in support of these elements to prevent this motion to dismiss. See Paulet. Quote, the complaint contains only the conclusory statement that the emotional distress covered by the plaintiffs was severe and of such a nature that no reasonable person could be expected to endure it. This statement does not constitute an allegation of fact, but rather a recitation of the element of severe emotional distress. For the above reasons, Kaylee's claims for intentional, reckless, or negligent infliction of emotional distress fail as a matter of law and must be dismissed. Conclusion. For the reasons stated above, the defendant, Karen Reed, respectfully requests that this honorable court allow this motion and enter an order dismissing counts 10, 11, 12, and 13 of the plaintiff's complaint. XOXO. William Kevel Jr., Christopher George, Marissa Palladini, Melican Porter in Boston for the defendant, Karen Reed. Get some questions, and then we can look at the opposition. And this is exactly what I thought the motion to dismiss would be based on, to dismiss the emotional distress claims as a matter of law. They can't ask to dismiss any allegations about the car accident because those are questions of fact. And so right now they are just making this motion for the judge to take the complaint as he finds it. What's within the four corners of the complaint? What are they alleging? Is it enough under the law to state a cause of action for those specific torts? Picking up what I'm laying down. Betsy says, I literally couldn't make it through my day without you. Love you with all my heart. Oh, thanks, Betsy, for your 20. Thanks for your 20, Betsy. I appreciate you. Beth Ellen says, I'm confused. How would the niece overhear her phone calls if Karen didn't know where he was at 6 a.m.? Sounds like Kaylee was coached by Jen McCabe. No, she had to borrow Kaylee's phone to call Jen McCabe because she did not have Jen McCabe's contact info in her phone. So Kaylee was there when she made the phone calls to Jen McCabe. And those are the things that Kaylee says or testified that Karen said in front of her. And because she said those things like maybe he was hit by a plow, maybe I hit him, that it caused her severe emotional distress. But what they're saying is That doesn't rise to the level. Doesn't rise to the level. Thank you for your super chat. How were the OJ civil depositions released? I don't know, Joanna or Jonna. That may have been many years after. That was a California case. This is Massachusetts. I'm telling you what I know. It may have been many years later. I don't rightly know. I don't rightly know because I don't know when they were released. I don't know how they got released. I just don't know. But I will tell you with certainty that during the pendency of this civil case, nobody will see the depositions. In my opinion, if anybody else is a Massachusetts barred attorney and can tell me otherwise, please, by all means, put it in the chat. Okay. Everyone understand what we got so far? Also, they're saying that under the law, the wrongful death statute of Massachusetts, because John died without a spouse or children, this brings me all the way back to future interests and like the rights of survivorship and who inherits things. I guess John didn't have a will, but if a person in John's position dies without children or a spouse, their assets go to their parents if they are still living. Where are my law students and my lawyers in the chat? Do you remember future interests? I did so well in that class. I think I got an A in future interests. Like that was crazy. Because that's some crazy stuff, but it's all very logical to me. His adopted kids would not be next of kin. They are not next of kin. The next of kin in this specific case, Lily, are his parents. I don't know that he adopted them. I think he was their legal guardian. But unless he had a will that named them as his heirs, under the wrongful death statute, his parents are not allowed to include any other causes of action other than what they are entitled to under the wrongful death statute. Okay. Okay. I don't know who has, I think the children live with Peggy O'Keefe in Canton, in the house that John lived in. If anybody has any other information, TJB says he never formally adopted them. Thank you. Sugar Muffin became a new member. Welcome, welcome, welcome. Exhibit A to the motion is simply the complaint, which we have been through extensively during the first stream I did on this civil action. So we do not need to review that right now. Oops. $40, $42. Let me just, the plaintiff's response to this is 55 pages. I just want to see if any of it is exhibits or if it's like 55 pages of actual reading. A lot of it is exhibits. Okay. All right. So the next thing we're going to look at is the plaintiff's opposition to this motion to dismiss. Moving on. Amber Heard's deposition, you saw her deposition during the trial. You got an actual physical copy of the transcript, or they played portions of it because it was videotaped. That was in Virginia, correct? Okay, this is thanks, Richie. Thanks, Richie. Richie is here from Microdots. If you haven't watched all of his recent droppings, please go do it. And I'm really waiting for your next one that you're teasing over on the socials. I can't wait for that one. The one that's going to show that Aiden Carney was absolutely 100% set up to go to jail. I can't wait for that. Can't wait because I knew somebody, you, would put all the pieces together and put that into a proper presentation that could be used in the courtroom. Easy enough for everyone to see the truth of what happened. I can't wait. And tomorrow we have Aiden's hearing at 2 p.m. So it's a full week. Everyone loves microdots. Here we go. This is docket number 42 in the Paul O'Keefe et al. Versus Karen Reed et al. Case in Plymouth, Massachusetts. Hold on a second. And support in my cup. All right. Plaintiff's memorandum in opposition to defendant Karen Reed's motion to dismiss the plaintiff's complaint. Introduction. Defendant Karen Reed inaccurately styled her motion as a motion to dismiss the plaintiff's complaint, when in reality it only seeks to dismiss several counts sounding in emotional distress, knowing that the media would pick up on the 9CE filing. Okay, well, that's ridiculous. But okay, whatever. That was on July 9th. Today's, what did I say? Today is August 12th. That's how long we've been waiting for the papers. And I, at least, have said, anybody who knows anything about lawsuits knows that it's to dismiss certain causes of action. Okay, but what else? Sounds good when I read it on TV, and then they can clip it later, and then they can put it wherever they want to put it. The case focuses on the tragic wrongful death of a beloved Boston police officer and the catastrophic losses to the deceased's close family members left behind. The plaintiffs in this case, the parents, brother, and niece of the decedent, John Joseph O'Keefe III, collectively plaintiffs or the O'Keefe family, allege that the defendant Karen Reed, while drunk driving, struck John O'Keefe, and then they put JJ in parens, with her SUV and left him gravely injured to die outside alone in emerging blizzard conditions. Instead of calling for help during those critical early morning hours, plaintiffs allege that Reed awakened JJ's 14-year-old niece, Kaylee, in a panic and exploited her as part of Reed's attempt to deflect and to frame a false narrative around JJ's death. Okay. Footnote 1, which is here on page 1, says, Defendant Reed served her motion to dismiss on or about July 9th, 2025, on or about July 25th and July 29th, after having answered plaintiff's complaint. Defendant's Waterfall Bar and Grill and C.F. McCarthy's sought to join defendant Reed's motion to dismiss, and adopting the same arguments raised by Reed. For the same reasons articulated herein, the bar defendant's motions should also be denied. The O'Keefe family has suffered and continues to suffer immense emotional trauma from this wrongful death, which has been further intensified by the unyielding barrage of harassment and ridicule by Reed and her supporters targeting the grieving family. Reed's campaign of disinformation designed to obfuscate the truth and to attack the O'Keefe family not only deprives them of justice, but also amplifies their grief and the loss of their beloved family member. Well, may look nice on page 2, but you can't add to your damages by just saying stuff like that or add causes of action, because the statute of limitations has expired. In Massachusetts, it is 3 years from the date of death for a wrongful death case, which is pretty generous, actually. Reed and her family went to great lengths to obtain orders from this court shielding them from convening discovery in this civil action during the pendency of the criminal matter. Well, I'm here to tell you that that's absolutely normal. Now that the stay has been lifted and the O'Keefe family is allowed to proceed, Reed asked this court to extinguish prematurely numerous legitimate claims made by the plaintiffs, largely based upon form over substance before any discovery occurs. Well, here's the thing. When you plead it, you have to plead it very specifically enough that it can survive a motion to dismiss for failure to state a claim. And that is what this is. The only issue that this court needs to resolve today is whether, assuming all factual allegations to be true and indulging every reasonable inference in plaintiff's favor, the complaint plausibly suggests that plaintiffs are entitled to relief on the infliction of emotional distress claims. The answer to that question is a resounding yes. As will be demonstrated below, there is no bright line test for plaintiff's infliction of emotional distress claims. Each claim requires an independent factual analysis on a case-by-case basis, which cannot be resolved at this stage of the lawsuit and without adequate discovery. Whether the O'Keefe family suffered shock closely on the heels of Reed's actions and JJ's death, and whether Reed's subsequent conduct rises to the level of extreme or outrageous, are questions prematurely raised to this court. See Ocasio-Hernandez, First Circuit case from 2011, which says recognizing chain of events leading to defendant's actions may often be unavailable to a plaintiff at this early stage of the litigation. But here, the chain of events is known to you, you know, or what you're alleging is that she hit him at some point after midnight, and that then she went home, and that you didn't witness the car accident. All of that stuff is not contested. And that you saw his body at the hospital, that's what caused you emotional distress. And the phone calls, I mean, everything is known to them. Can anybody point out any facts that are unavailable to the plaintiff or the plaintiffs at this early stage of the litigation? Number one, she was acquitted by a jury who said there was no car accident. And number two, there's no motor vehicle accident report. And I've said that this is going to be an uphill battle. Now, understand that the plaintiff attorneys are working likely on contingency. They receive a percentage of any settlement or verdict or anything that they collect from the defendants and or their insurance companies. And there are insurance companies involved that will pay any judgment or settle the claim. Therefore, the plaintiff's attorneys do not get paid unless they win. The O'Keefes are not paying them by the hour. They don't get paid unless they win, which is why plaintiff's attorneys often don't take cases that they can't win. You have to be very selective about the cases that you take as a plaintiff's lawyer, because you could spend hundreds or thousands of hours on a case, and if you lose, you don't get paid. The defense attorneys, in this case, are likely being paid by the insurance carriers involved. Karen does not have to pay for the attorneys. The attorneys are being paid by the insurance company. That's why you have car insurance. You have car insurance in most states. Some states are different, so I'm just going to speak generally here. But in the event that you're involved in a car accident and you get sued, putting aside all of the states that don't require liability insurance for a minute, if you live in a state where you must, under the law, carry liability insurance, which in New York we have to, and Massachusetts, I believe you have to also. If you are sued because of a car accident, your car insurance company will appoint attorneys to represent you, and they will pay those attorneys up to your policy limits. And so if your policy limits are, let's say, $100,000 per person, $300,000 per accident, up to the limit of, let's say, $300,000. If you have an umbrella policy, that's an additional sum of money that can be added to the, let's say, pot, the proverbial pot. Say you have $1 million umbrella, and let's say you have $500,000 in insurance. There's a total of $1.5 million that your insurance company could have to pay out on your behalf, assuming the case is worth that. So Karen's lawyers are likely being paid by her carrier, and the plaintiff's attorneys are not being paid until if and when this case settles. So of course, they're going to do everything they can to try and keep all of these causes of action in play because they want to get paid. And rightly so. They shouldn't have to, Karen's attorneys worked for free in her criminal case, but the plaintiff's lawyers want to get paid. Wherefore, the O'Keefe family respectfully requests that this honorable court deny defendant Karen Reed's motion to dismiss and allow the plaintiffs an opportunity to conduct discovery because the plaintiffs have averred plausible claims for relief against Reed for infliction of emotional distress. Microdots doesn't even own an umbrella. And Sheila says, but there was no car accident. Exactly. However, for purposes of this motion only, the court must accept everything the plaintiffs allege in their complaint to be true. And in their complaint, they say there was a car accident. So for purposes of this motion only, the court has to say, okay, there was a car accident. And even if there was a car accident, do the things that happened after that rise to the level that is required to recover on these causes of action? I've said from the beginning, no. I still say no. Relevant factual allegations. Plaintiffs allege the following facts relevant to the subject motion, which must be accepted as true and indulging every reasonable inference in their favor. Defendant Karen Reed consumed at least 9 alcoholic drinks over approximately 3 hours at 2 Canton bars between the hours of approximately 9 p.m. on January 28, 2022 and 12 a.m. on January 29th of 2022. See the complaint. Thereafter, in a state of extreme intoxication, Karen Reed drove JJ to 34 Fairview Road in Canton, at which time JJ exited Reed's SUV. At some point before 1 a.m., Reed accelerated and struck JJ with her SUV. As a result of the impact, JJ was knocked down onto the ground in front of 34 Fairview, suffering serious injury. Remember, these are allegations, doesn't make them true. Reed, still inebriated, left JJ seriously injured in front of 34 Fairview with emerging blizzard conditions and drove to JJ's residence at One Meadows Avenue, where JJ's 14-year-old niece, Kaylee, was sound asleep. During those early morning hours, Reed knew that she had struck JJ with her SUV and left him seriously injured and dying alone in the snow. Reed did not call 911, seek assistance, or return to the scene. Instead, knowing that Kaylee was a vulnerable minor who had already lost both of her parents, tragically, Reed woke Kaylee in a panic, stating that something had happened to JJ and that Kaylee's surrogate father was dead. It was at or around the same time that Reed began to devise a false narrative of events in the interest of self-preservation. In the presence of Kaylee, and instead of calling 911, Reed called various acquaintances, proclaiming, among other things, that JJ never came home and that he may have been hit by a snowplow. Therefore, at or about 5 a.m., Reed departed JJ's residence, leaving Kaylee frightened, traumatized, and alone. At around 6 a.m., at or around 6 a.m. the same day, Reed returned to 34 Fairview and observed JJ on the ground, buried in the snow, where she had earlier left him to die. Shortly thereafter, JJ's parents, John Sr. and Margaret O'Keefe and brother, Paul O'Keefe, learned of JJ's condition and admission to the hospital. The O'Keefe family came upon JJ's body at the hospital shortly after JJ was pronounced dead at approximately 7:50 a.m. Learning of JJ's injuries and subsequently witnessing the consequences of Reed's actions at the hospital resulted in severe and profound emotional trauma to the O'Keefe family. Thereafter, Reed deliberately fabricated a conspiracy and launched a public campaign of disinformation designed to obfuscate the truth and to deprive the O'Keefe family of justice for JJ, which has caused severe and profound emotional distress to the already vulnerable O'Keefe family. Argument. As discussed further below, this honorable court should deny Karen Reed's motion to dismiss because the allegations in the plaintiff's complaint, taken as true and constructed in the plaintiff's favor, state claims for relief that are plausible on their face And plaintiff's infliction of emotional distress claims require that a fact-intensive analysis, which is not ripe for deciding at this early stage of the lawsuit and without adequate discovery. The plaintiff should prevail on a motion to dismiss under Rule 12b-6 if, quote, the factual allegations in the complaint assumed to be true, granting the pleader all reasonable inferences that may be drawn from those factual allegations, possess enough heft plausibly to suggest that the pleader is entitled to relief. A complaint does not have to evince a one-on-one relationship or a one-to-one relationship between any single allegation and a necessary element of the cause of action. Rather, the plausibility standard should be applied to the claim as a whole. The critical question is whether the claim, viewed holistically, is made plausible by the cumulative effect of the factual allegations contained in the complaint. These generous and indulgent criteria have reduced a plaintiff's obstacle in surmounting a failure to state a claim to a minimal hurdle. It is a relatively light burden to be carried in maintaining a complaint. Roman 1, negligent infliction of emotional distress is an independent cause of action separate and distinct from wrongful death damages. As a preliminary defense, Defendant Reed argues that JJ's parents, Margaret and John O'Keefe II, are precluded from asserting a negligent infliction of emotional distress claim, NIED, against Reed, because any emotional distress damages arising from the NIED claim would be duplicative of the loss of consortium damages available under the wrongful death statute. Reed, however, cites no applicable case law to support her argument because no such precedent exists. The individual emotional distress damages recoverable under NIED are entirely unrelated to damages for the value of lost life under our wrongful death statute, which defendant refers to as a loss of consortium. In fact, traditional emotional distress damages are expressly disallowed as a component of wrongful death damages. This legal principle is clear from the plain language of our Superior Court model jury instructions on wrongful death damages to next of kin, which states in pertinent part. In a wrongful death case like this one, a person who negligently causes someone's death must pay money damages to the surviving spouse, in this case would be next of kin, for the value of that lost life. For purposes of the wrongful death claim, the phrase lost value includes, but is not limited to, the loss of reasonably anticipated services, protection, care, assistance, companionship, society, comfort, guidance, net income, support, counsel, and advice. Lost value does not include grief, anguish, or bereavement at the decedent's death. C, no compensation for bereavement. While you must consider certain losses, such as a loss of companionship and net income, you may not consider certain other things. Although losing a loved one is very difficult emotionally, the law does not allow next of kin to recover damages for their grief, anguish, or bereavement. The monetary value of DCD's life depends upon the companionship, emotional, financial, and other benefits she or he would have provided to the next of kin if they had lived. Therefore, you must not award damages for the next of kin's grief, anguish, or bereavement. A claim for damages based on emotional distress does not include an administrator's claim for loss of consortium, which will be present in every wrongful death action such as this. Since emotional distress is a wrong to the plaintiff distinct from that done to his son and the statutory beneficiaries of the decedent, it is not a duplicative remedy and is not preempted by the wrongful death statute. In sum, the wrongful death statute creates a derivative right of recovery for statutory beneficiaries for the lost value of the decedent or in other words, the loss of affection, services, financial support, and other benefits the decedent would have provided had he lived. In contrast, a claim for negligent infliction of emotional distress is an independent cause of action based upon the individual claimant experiencing or witnessing the consequences of a defendant's wrongful conduct, which permits recovery of emotional distress damages otherwise unavailable to beneficiaries under the wrongful death statute. All right, this sounds like Greek to you, I'm sure, but let me just try and explain it in a way that is a little more easily digestible. For example, let's say, God forbid, my husband dies. He's killed in an accident, let's say. And let's say that at the time of his death, he was 40 years old and he was making $1 million a year. Typically, what a plaintiff's attorney does is hire an economist to come in as an expert witness to evaluate all of the pecuniary loss in tangible form. For example, how long a person is expected to work. So let's say the plaintiff was 40 at the time of death, and then let's say they're expected to work until they're 65. It's 25 years of lost income at $1 million a year, plus cost of living increases and other benefits. And they add it all up and they come up with a number and they present that number to the jury. And there's an expert witness to put a number on all of the tangible elements of loss of services. Then it's up to the jury to decide how much it's worth to the children, to the surviving spouse, to not have such things as your father there to walk you down the aisle. The emotional support to the wife for however long their life expectancy is. And all of those are non-tangible elements of damages, and the jury can award whatever they want for that. And the plaintiff makes their arguments such as like that. Are you picking up what I'm laying down here? What Karen's attorneys are saying is because they are the next of kin, the parents, they do not have independent causes of action for emotional distress claims. And not only that, even if they did, the emotional distress claims that they're describing in their complaint do not rise to the level of being able to collect because they weren't there when it happened. They didn't come upon him close in time to this alleged car accident, etc. We getting it? We picking up what I'm laying down here? And because of all that, the defense motion to dismiss must be denied. The suit, you can usually, all right, Noni says, though, then actually, why is this suit for such a relatively small amount? Most states, including New York, you're not allowed to put a dollar amount in your complaint anymore. And so I don't know what it said in the complaint here. Did it say $50,000? The only reason that they put $50,000 in there is to get it into the jurisdiction of the higher court, because cases worth less than $50,000 can only, I think, go to district court. I'm in New York, but that's my guess. You have to have a minimum to get into superior court. But the jury can award whatever number they want. Okay. 75,000, it said 75,000. Maybe that's the jurisdictional minimum. I'm not sure. Okay. Vintage Girl says they didn't convict her. How can they get civil compensation? Well, civil court rules much different. The burden of proof is much less. It's a preponderance of the evidence, which is just a little tiny bit. Oh, see the girl on the scales of justice usually is behind me. But if you can tip the scales a little tiny bit, that's a preponderance of the evidence. It's a different standard than beyond a reasonable doubt. So, for example, the most popular example is O.J. Simpson was acquitted by a jury, the criminal death of his wife, Nicole Brown Simpson, or his ex-wife, Nicole Brown Simpson, and Ron, can't remember his name right now, but they were successful in civil court because the burden of proof is different. But in here, they got to prove there was a car accident too. So I don't know. Nicole Brown. Yeah, that's why. Exactly. Because he did. Kathy says because he did it. Ron Goldman. I'm sorry, Ron Goldman. My brain is mush right now. It's Ron Goldman. Thank you. Rest in peace. Roman 2, the complaint alleges sufficient grounds to hold Karen Reed liable for negligent infliction of emotional distress. Defendant Reed cannot demonstrate that she's entitled to relief under Rule 12 as a matter of law based on the pleadings alone. Defendant argues that the O'Keefe family's shock from experiencing and witnessing the consequences of Reed's negligence was not sufficiently contemporaneous to support a claim for NIED. Although courts have imposed relational, temporal, and spatial limits on the scope of liability for emotional harm in this context, there is no bright line test that controls which claims are compensable and which claims are not. Instead, Massachusetts courts employ the traditional tort doctrine of reasonable foreseeability to govern bystander recovery, stating, quote, the determination whether there should be liability for the injury sustained depends on a number of factors, such as where, when, and how the injury to the third party entered into the consciousness of the claimant and what degree there was of familial or other relationship between the claimant and the third person. Every effort must be made to avoid arbitrary lines which unnecessarily produce incongruous and indefensible results. Well, you also can't open up the floodgates. Margaret John Sr. and Paul O'Keefe's NIED claims. Oh, that's not a very straight line. Hello, Red Pen. Let's play nice, shall we? Defendant attempts to draw an arbitrary line between the approximate time of Reed's collision with JJ in front of 34 Fairview and the time that the O'Keefe family subsequently observed JJ's lifeless body without considering other relevant factors to argue that the family's NIED claims fail as a matter of law. There is no requirement that the shock experienced by the O'Keefe family from the consequences of Reed's negligence be immediate in a literal sense, as suggested by the defendant. Quote, a plaintiff who rushes onto the accident scene and finds a loved one injured has no greater entitlement to compensation for that shock than a plaintiff who rushes instead to the hospital, so long as the shock follows closely on the heels of the accident. The two types of injury are equally foreseeable. And that is citing the same case that the the defense cited, Ferreter, and that is a 1980 case, which they say holds that the trial court erred in granting summary judgment to defendant on plaintiff's NIED claim, where plaintiffs first observed family members' injuries upon arriving to hospital, not at the scene of the accident, because on summary judgment, it may be inferred that the shock occurred immediately following the accident, superseded by statute on other grounds, as stated in Sheehan v. Weaver. Furthermore, the proximity of the shock experienced by the plaintiff is neither anchored to the specific time of the collision nor the time at which the O'Keefe family first observed JJ in the hospital, but rather where, when, and how the injury to JJ entered into the consciousness of his family. In Zachary, a nurse negligently injected the plaintiff's father with an unknown substance causing him injury. While the plaintiff's daughter learned of her father's injury on the same day via telephone, she did not observe her father's suffering in person, nor learn of the nurse's wrongdoing until the following day. Acknowledging that the issue was a close one, the court denied the defendant's motion for summary judgment and permitted plaintiff's NIED claim to go forward to trial. And that is a case from 1999. Here, plaintiff's NIED allegations must be viewed through the lens of the, you expect me to pronounce that, Iannacino standard, which is far more generous and forgiving than the summary judgment scrutiny applied in Ferreter and Zachary, where the court determined that the plaintiff's NIED claims should proceed to trial. While the collision between Reed's SUV and JJ occurred sometime around 12:30 a.m. on January 29th of 2022, Reed's wrongful conduct and the consequences thereof continued into the early morning hours thereafter. Reed left JJ helpless and seriously injured in front of 34 Fairview when she left the scene and returned to JJ's residence. Instead of calling for assistance, while JJ lay suffering and freezing in a blizzard-like conditions, Reed woke Kaylee and called various acquaintances to begin laying the foundation for a false narrative of events. Well, it was approximately 6 a.m. that Reed returned to 34 Fairview and emergency responders transported JJ to the hospital. It was around this time that the O'Keefe family immediately learned of JJ's injuries and admission to the hospital. I think because Carrie Roberts called them, right? So you can expect Carrie Roberts to be deposed in this case. These claims get that far. The O'Keefe family rushed to the hospital and came upon JJ's body only minutes after he was pronounced dead at approximately 7:50 a.m. It is abundantly clear from the circumstances of where, when, and how the injury to JJ entered into the consciousness of the family that the shock experienced by the O'Keefe family followed sufficiently closely on the heels of Reed's alleged wrongdoing and the consequences to JJ to state a viable claim for relief for NIED. Footnote 2, which is a very long footnote. Plaintiff's allegations are substantially more comparable to the circumstances in Ferreter and Zachary than the NIED cases relied upon by defendant, none of which involved review of a motion to dismiss. And I'll leave that up so that you can read it to yourself later. And I can't really opine on this until I myself have a chance to read the case law, which, as you know, this is a cold read for me. I will say courts are hesitant to dismiss cases without a lot of discovery being done. So the chances of this actually being granted are a little bit slim. But I've said from the beginning that I did not think that these emotional claims were strong. Will they survive a motion to dismiss? Likely. Wherefore, defendant's motion to dismiss the O'Keefe family's NIED claims must be denied. B. Kaylee, NIED claims. Exactly. You can sue anyone you want for anything at all, but you still need to prove your case. Burden of proof is always on the accuser, well, or in the plaintiff, right? Thank you. Got milk for me? You are right. And you can sue for any amount you want. Doesn't mean you're going to get it. And it doesn't mean that you'll ever see a dime, but AJ is going to have fun with the depositions, says Ultra Dog. And ARCA can testify in the civil suit. Absolutely. They're going to be the perfect experts because they're already familiar with the case. Next, defendant argues that JJ's niece Kaylee, whom JJ was responsible for raising, cannot maintain a claim for NIED as a matter of law because Kaylee never observed Reed's conduct that caused JJ's death, nor observed his body at the hospital. If this court was to accept the defendant's position as true, some plaintiffs would never be able to satisfy such a standard, i.e., a blind person would not be able to see an accident or victim, a body reduced to ash in an explosion, or fire would not be observable. Yet nevertheless experience a traumatic event with other senses that results in the individual suffering severe emotional harm and distress. Further, this assumption presumes that Kaylee was unable to experience the consequences of Reed's wrongdoing through other means, such as sight, sound, interoception, and mind. Defendant's argument, again, fails to consider the totality of the circumstances present here, including where, when, and how the injury to JJ entered into the consciousness of Kaylee. While Kaylee may not have witnessed the initial collision which resulted in JJ's injuries, she experienced firsthand the trauma, panic, and chaos that ensued shortly thereafter. Within 4 hours of the collision and amid Reed's sustained wrongdoing, a vulnerable 14-year-old Kaylee, who had already lost both of her parents tragically, was abruptly awakened at 4:30 a.m. by a hysterical, screaming Karen Reed talking about hitting JJ with her SUV, involving Kaylee in phone calls about JJ being struck by a snowplow and proclaiming that Kaylee's surrogate father, whom she had come to depend on, was dead. All this occurring, by the way, before JJ's body was discovered buried under the snow on the lawn at 34 Fairview. I feel so bad for the kids too. Thank you, Teacup Hug. I do too. Notwithstanding the fact that Kaylee did not physically observe the collision or JJ's body at the hospital, Kaylee witnessed firsthand Reed admitting to her wrongdoings and Kaylee witnessed firsthand Reed admitting to her wrongdoings and simultaneously perceived and experienced the gravity of harm caused by Reed through a sudden and overwhelming onslaught of sensory stimulation invading her consciousness. Let me tell you while I'm thinking of it, another reason why I think it was a bad idea to bring a case on behalf of the niece. And that is because when you bring an emotional claim in a civil case, your entire psychiatric history is fair game. It's fair game because the defense has the right to say all of this is pre-existing. What happened here did not cause these emotional injuries because the person was already seeing a therapist for years and years and years and years and years, and all of that stuff becomes discoverable. And do you really think that the 14-year-old niece who lost both of her parents, in fact, her father, Hank Brennan, had zero respect for this family, the O'Keefe family, and John's niece, when he had, I don't even think the other person read those text messages. When he read those text messages into open court about how Kaylee's father, the circumstances surrounding his death. And so it is likely that she had been undergoing some sort of therapy. And all of that comes into play. And it's terrible. Why? For what? That also goes for Paul O'Keefe, Peggy O'Keefe, and John's dad. They're claiming emotional injuries. Their entire psychiatric history throughout the course of their lives will become fair game. And they also, in order to prove psychiatric damages and emotional damages, they have to have been seeing a therapist or a doctor of some sort who can come into court and back up these claims. I don't know. Is it worth it? Emotional distress as the concept has evolved in this Commonwealth is a severe psychological shock directly resulting from experiencing or witnessing the effects of a defendant's conduct. To suggest that Kaylee does not meet the lowest threshold to plausibly show that she is entitled to relief for NIED would be a blatant miscarriage of justice. Yeah, let's drag her through some more depositions. And she already had to testify twice. Wherefore, defendant's motion to dismiss Kaylee's NIED claim must be denied. 3. The plaintiff's complaint, viewed holistically, suggests that the O'Keefe family is entitled to relief for Reed's intentional, reckless infliction of emotional distress, so plaintiff should be afforded the opportunity to conduct discovery. In seeking to dismiss the plaintiff's claims for reckless and/or intentional infliction of emotional distress, herein, IIED, defendant principally argues that the complaint lacks sufficient details to establish the elements of the claim and that the conduct alleged does not rise to the level of extreme or outrageous to warrant recovery for IIED. In doing so, however, the defendant disregards the totality of the circumstances and all reasonable inferences construed in the plaintiff's favor. The critical question is whether the claim, viewed holistically, is made plausible by the cumulative effect of the factual allegations contained in the complaint. Requiring highly specific facts within the complaint is misplaced at the pleading stage and is reserved for summary judgment and trial. As this court has emphasized, notwithstanding the neoteric plausibility standard, no detailed factual allegations are required in a complaint, citing 2 cases. In evaluating whether defendant's conduct was extreme or outrageous, the court should not isolate individual incidents, but rather should, quote, draw reasonable inferences from the totality of the circumstances, including whether the individual at whom the conduct is directed is known to be particularly susceptible to infliction of emotional distress. Citing a 1979 case and a learned treatise, the Restatement Second of Torts from 1965. Further, The court should put as harsh a face on the defendant's actions as the basic facts would reasonably allow. There's an issue for the jury if reasonable people could differ on whether the conduct is extreme and outrageous. The defendant's motion to dismiss the O'Keefe family's claims for IIED should be denied because, like their claims for NIED, the plaintiff's intentional infliction of emotional distress claims require a fact-intensive analysis based on the totality of the circumstances, which is more appropriate to address a summary judgment following completion of discovery. So now is a good time to point out that this motion, if denied now, can be made again at the completion of discovery and prior to trial. Section A, Kaylee's IIED claim. Footnote 3. Defendant alleges that Kaylee fails to state a claim for any infliction of emotional distress claims because the complaint does not clearly state what conduct applies to what type of claim. Plaintiffs are entitled to set forth multiple claims for relief, alternatively or hypothetically, regardless of consistency, so long as the claims viewed holistically are made plausible by the cumulative effect of the factual allegations contained in the complaint. Dismissal is not warranted. A complaint is not subject to dismissal if it would support relief on any theory of law. The defendant discounts two factors of critical importance in claiming that Reed's conduct directed toward Kaylee during the early morning hours of January 29th of 2022 was not extreme or outrageous. To wit, Kaylee's age and vulnerability. The relationship of the plaintiff to the defendant and the knowledge of the plaintiff's sensitivities is an important consideration in determining whether the challenged conduct satisfies the extreme and outrageous conduct requirement. A defendant's knowledge of a plaintiff's vulnerability to emotional distress may compound the effect of the defendant's behavior, causing it to rise to the level of extreme and outrageous. And there's a whole bunch of case law. Here, Karen Reed's relationship with Kaylee leading up to and including the time of her wrongful conduct is a key factor in considering whether Kaylee states a plausible claim for IIED. During her extended relationship with JJ, Reed inevitably played an important role in 14-year-old Kaylee's life as well. Yeah, which is exactly why you shouldn't have forced her to testify against her, because she's got to live with that. Reed explicitly knew that Kaylee was particularly susceptible to emotional distress, having already lost both of her parents tragically. It's tragic. Nevertheless, after striking JJ with her SUV in a state of intoxication and leaving him seriously injured outside in blizzard-like conditions, Reed returned to JJ's home and abruptly and hysterically awakened 14-year-old Kaylee in the middle of the night to talk about the death of a person whom Kaylee had come to depend on as a surrogate father since the tragic death of her own parents. Footnote 4. If there was no collision, as Reed claims, and Reed simply left JJ unharmed at 34 Fairview and returned home, why did Reed feel compelled to awaken young Kaylee in the middle of the night to tell her that her surrogate father was hit by a car or snowplow and was dead? Well, that is a question of fact, number one. And number two, she didn't have Jennifer McCabe's contact info in her phone, and she needed to call her to find out where John was. If Reed believed this to be true at the time, then her actions directed toward Kaylee that morning far exceed the bounds of extreme and outrageous conduct. Instead of calling 911 while JJ lay dying in the cold, Reed deliberately involved Kaylee in her plan to cover up her involvement by calling various acquaintances in front of Kaylee, proclaiming, among other things, that JJ never came home and that he may have been hit by a snowplow. Knowing that her words and actions caused Kaylee severe emotional distress, Reed then stranded Kaylee home alone, shocked and frightened with no one to comfort her. Footnote 5. In viewing Kaylee's IIED claim from the totality of the circumstances, Reed's alleged ongoing wrongful conduct in propagating her false narrative, as discussed in more detail below, is also relevant to Kaylee's IIED claim because it reflects a prolonged pattern of calculated conduct designed to obfuscate the truth, to polarize the public, and to pit Reed and her supporters against the O'Keefe family. Yeah, they really said deliberate plan. Yes, they did. In drawing all reasonable inferences from the totality of the circumstances here, including Kaylee's age, vulnerability, and relationship with Reed, and in placing as harsh a face on Reed's actions as the basic facts would reasonably allow, it is clear that reasonable people could differ on whether the conduct is extreme and outrageous. It is for the jury in such instances to decide whether Reed's conduct was rude and clumsy or extreme and outrageous. Therefore, the defendant's motion to dismiss Kaylee's IIED claim must be denied. B. Margaret John Sr. and Paul O'Keefe's IIED claims. Let's just go to chat for a minute. Welcome, Sugar Muffin. RJ Larson, that is wild that they are bringing up the daughter and using her. How about being home alone? LOL. Wild. Miss you. Miss you, Mel. Thanks for your 5. And John had left her home alone, right? I don't know. Lettuce. Melanie, what if Karen wins and the plaintiff's attorneys are doing all of this to get paid after? Who pays the lawyers if the O'Keefes lose? Nobody. They don't get paid. They don't get paid. They take the loss. RJ Larson, bogus BS. What about that GoFundMe? I don't know who made it. Who made a GoFundMe? Did the O'Keefes make a GoFundMe? I don't know anything about that. Thanks, RJ. Haley hopes if Karen could prove that John hadn't had a relationship with his mom prior to his death, could that affect their case? Well, it could go to the damages, right? Could go to any loss of consortium or loss of the love and compassion of your loved one. If they didn't have a relationship, it could go to the value of the damages. So yes, if it survives, if the claim survives. Thanks, Haley. Karen, thanks for becoming a YouTube, a new member. Beth Ellen, so in other words, as soon as Karen called Jen, she had already set up the accident and Jen convinced Karen she probably ran him over. It's a theory. Oh, my thing thinks I'm talking to it. Thanks, Beth Ellen, for your 5. And Boston Girl, thank you for gifting a membership. Charissa, you're awesome. Yay, Gen X chick caught alive. Yay for you. Yay. Right. And Jen called her sister right after, says Aussie NQ. Does that show consciousness of guilt? 5:07 a.m.? I don't know. She lied about that too. Like all others' claims which defendant seeks to prematurely dismiss, the O'Keefe's family claims for IIED cannot be viewed in a vacuum. The court must evaluate whether the IIED claims viewed holistically are made plausible by the cumulative effect of the factual allegations contained in the complaint and drawing all reasonable inferences in the plaintiff's favor from the totality of the circumstances, including but not limited to the O'Keefe family's vulnerability to emotional distress resulting from the loss of a beloved son and brother. The core of the O'Keefe's family IIED claims allege that Reed, knowing that she was responsible for causing JJ's death, calculatedly and maliciously fabricated a conspiracy and launched a public campaign of disinformation designed to obfuscate the truth and to deprive the O'Keefe family of justice for JJ, which has caused severe and profound emotional distress to the already grieving and vulnerable family. Or, I'll break to say, in my opinion, a jury may find that she was just trying to defend herself. In support of her motion, defendant argues that the complaint lacks requisite factual averments concerning the O'Keefe family's claims for IIED and that plaintiffs cannot demonstrate, as a matter of law, that Reed's alleged conduct was intentionally directed towards the plaintiff, nor that such conduct was extreme or outrageous. First, there's no requirement that Reed intended her post-incident statements and conduct to cause emotional distress to the O'Keefe family. Quote, although denominated an intentional tort, a review of decisions in which the cause of action has survived a motion to dismiss indicates that the majority of such actions are based not on conduct engaged for the purpose of causing distress, but on conduct with which the actor should have known would result in distress. Neither is there a stringent requirement to plead highly specific facts or comprehensive allegations at this stage. It would be highly inequitable for this court to dismiss the O'Keefe family's IIED claims for want of specificity at this stage, whereas Karen Reed holds the key to the evidence needed to prove those claims, yet Reed has gone to great lengths to shield such evidence from discovery. I don't know. I tend to disagree with that fundamentally. How is anything that Karen says going to make their claims more specific with regard to when they got to the hospital, what they saw, how they suffered? That argument rings hollow with me. What say you? The stay of civil proceedings against Reed has only recently been lifted, and the subject motion was served before plaintiffs had any meaningful opportunity to conduct discovery, most notably Reed's deposition, regarding the very claims Reed seeks to dismiss. Footnote 6. I will also tell you that it is very common for civil cases to be stayed or put on hold during the pendency of a criminal case. Footnote 6 says plaintiff propounded initial requests for discovery on Reed via her counsel on or about July 24th of 2025. Oh, here's an affidavit of Tully. Oh, this is going to be good. That's Exhibit A. Hurry, let's get to Exhibit A. Hold on. No spoilers. This imbalance between the parties is precisely why generous and indulgent criteria have reduced a plaintiff's obstacle in surmounting a failure to state a claim to a minimal hurdle. The requirement of plausibility on a motion to dismiss simply calls for enough fact to raise a reasonable expectation that discovery will reveal evidence of the illegal conduct. While plaintiffs believe that discovery from Reed will substantiate and expand upon their claims of a false narrative, a public filing from Reed's criminal matter lends support to plaintiffs' IIED allegations. Oh, it's a public filing. And Exhibit A, footnote 7, is the affidavit of Detective Lieutenant Brian Tully of the Massachusetts State Police, dated January 22, 2024, which details his investigation in support of a search warrant issued for Karen Reed's cell phones pertaining to allegations of witness interference and conspiracy. Wait a second. Brian Tully's affidavit of January 2024. Okay. I'm like, why don't I do it January 22nd? John died on January 29th. Oh, yeah, because this is 2 years later when they tried to indict Karen and Aiden on conspiracy to commit witness intimidation. We're going to see his affidavit. I hope they didn't redact it. Pertaining to allegations of witness interference and conspiracy, this affidavit is part of an opposition filed by the Norfolk County DA in Reed's criminal matter, which was not under seal. Plaintiffs acknowledge that Reed was not indicted for the aforementioned allegations. According to the investigation of Detective Lieutenant Brian Tully, following her arrest in 2022, Reed began using an old friend as an intermediary to covertly share information about defense theories in her criminal case with a now well-known blogger via an encrypted messaging application. Wow. Is it Signal? Is it Natalie the German? Is it Aiden Carney, aka Turtle Boy? Oh, you want to bring all of them in too? Okay, let's go. See Exhibit A. According to Tully, Reed began secretly and selectively to filter non-public information to the blogger for publication including evidence, personal witness information, defense conspiracy theories, FBI involvement, and the impanelment of a federal grand jury. Footnote 8. Reed also allegedly coordinated meetings between the blogger and her defense team during which they discussed theories that other individuals were responsible for JJ's death, despite Reed's defense team claiming they never had any contact with the blogger. Oh, you better be able to prove that. Talk about writing stuff for the media, huh? Reed eventually began communicating with the blogger directly and allegedly controlled what content the blogger would publish on his platforms. At various points in time, the blogger made public comments about influencing Reed's jury pool, arresting the people who killed John O'Keefe, and inferred during a rally that the O'Keefe family's period of grief had expired and they were now fair game for trying to send an innocent woman to jail for the rest of her life. Without repeating the relatively minimal threshold for overcoming a motion to dismiss, a reasonable jury could conclude that Reed knew or should have known that she would cause severe emotional distress to an already grieving O'Keefe family when she struck their son and brother with her SUV, left JJ gravely injured to die in the cold, and deliberately contrived a conspiracy theory and orchestrated a public campaign of disinformation to shift the blame to innocent parties and to deprive the O'Keefe family of truth and justice. The plaintiffs acknowledge that these circumstances in this case are exceptional and certainly distinct from any of the IIED cases relied upon by the defendant, which only favors the view that a Rule 12b6 motion is an improper means to challenge the O'Keefe family's IIED claims. Going back to footnote number 9, which says media coverage regularly pitted the O'Keefes versus the Reeds, a product of what is believed to be a calculated campaign to polarize this case in the media and portray anyone who questions Reed's innocence as a villain. Simple internet, I would say it was the complete opposite. Anyone who thought Reed was innocent was portrayed as a villain and a grifter. A simple internet search will reveal some of the disturbing consequences of Reed's false narrative, including but not limited to public and online harassment of the O'Keefe family, crowds of Reed supporters or Reed's followers callously booing the grieving family as they enter court. We all know that's a lie. And taunting the O'Keefes by dancing in front of their home on video following Reed's acquittal of murder charges. That person was having a mental health crisis and had been dancing all over town, from what I heard, and had nothing to do with Karen Reed's acquittal. But let's put it in your papers that you know are going to be read by the media tonight. Wow. A jury, not this court, should resolve whether Reed's conduct was extreme and outrageous under the totality of the circumstances in this case. There's an issue for the jury if reasonable people could differ on whether the conduct is extreme and outrageous. At a minimum, the O'Keefe family deserves a fair opportunity to complete the discovery needed to prove their IIED claims. Conclusion. Wherefore, the plaintiffs respectfully request that this honorable court deny defendant Karen Reed's motion to dismiss in its entirety and to allow the plaintiffs an opportunity to conduct discovery because the plaintiffs have averred plausible claims for relief against Reed for infliction of emotional distress. Should this court determine that plaintiff's complaint fails to state a claim in any respect, the plaintiffs respectfully request that this court grant them leave to amend the complaint following the completion of discovery in order to cure the deficiency, if any. Plaintiffs respectfully request a hearing on this matter. Okay. They want to orally argue this. Will they get it? XOXO. Mark Diller, Esquire of Diller Law. Exhibit A. We're going to get to see it. Oh, yeah. Oh, yes. Oh, yes. Oh, yes. It's the search warrant. Have we seen this before? This is the search warrant for Tully to search Karen's phone in January of 2024. Have we seen this? Hold, please. Okay, here we go. This is a search warrant application. It's got its own docket number too. And this is his probable cause affidavit that Tully filled out to be able to search Karen's phone. Here's what he says. It says, proof by affidavit, which is hereby incorporated by reference, has been made this day, and I find that there is probable cause to believe that the property described below is intended for use or has been used as a means of committing a crime and is evidence of a crime or is evidence of criminal activity. You are therefore commanded within a reasonable time and in no event later than 7 days from the issuance of this search warrant to search for the following property: any mobile device capable of communicating, and cell phones used by Karen Reed. And then it says seizure only, no search of data as outlined in affidavit. The data on any cell phone seized may be copied, provided no search of that data will be done absent further warrant or order of the court. Says you are not authorized to conduct the search at any time during the night. You are not authorized to enter the premises without announcement. You are not authorized, versus you are not also commanded to search any person present who may be found to have such property in his or her possession or under his or her control, or to whom such property may have been delivered. And look who signed off on that. Judge Krupp. Judge Peter Krupp signed off on this search warrant on January 22nd, 2024. Judge Krupp was the judge that we just watched the hearing with Rosemary Scapicchio before this stream on the Miles King case. And the witness, the first administrative justice, is Michael Ricciuti. And here is the return of the search warrant, meaning after the officer served the search warrant, here's what he collected on January 22nd of 2024. An Apple iPhone purple with green case and an Apple iPhone white with clear case. 2 cell phones belonging to Karen Reed. And the inventory was made in the presence of guess who? Lieutenant John Fanning. XOXO, Brian Tully made the search. Fanning was there to witness it coming in. Big old bag of conflict. And it was at 1:24:24, 14:45 hours. Tully showed up at Karen's house with a warrant to collect her phones, and he did. Here's the application for the search warrant. Brian Tully, Detective Lieutenant. And here's what he had to sign to say that there was probable cause. Let's read it together. You ready? I, Detective Lieutenant Brian Tully, shield number 3520, am a Massachusetts State Police officer and have been a police officer since 2006. In July of 2012, I was assigned to the Norfolk State Police Detective Unit, where I have investigated and processed serious and violent crimes, including murder, taking of one's own life, sudden, suspicious, and unattended deaths, along with drug investigations. In 2019, I was promoted to the rank of sergeant and supervised homicide and violent crime investigations. In November of 2021, I was promoted to the rank of detective lieutenant and appointed unit commander of the Norfolk State Police Detective Unit, SPDU. I have participated in the execution of search warrants from which various types of evidence have been seized. I am trained in criminal investigations, including specifically homicides and death investigations and crime scene investigation. I have received specialized training and experience in the collection of physical evidence, crime scene processing, and the investigation of such cases. I have received specialized training to obtain and analyze cellular telephone data and call detail records in support of criminal investigations. I have testified as an expert witness regarding cell phone technology, cell phone forensics, and their use in criminal investigations. In one such case, Commonwealth v. Wilkerson, the Massachusetts SJC stated, I testified to my extensive training in applying CSLI records to criminal investigations. I have been an instructor for the Municipal Police Training Council on the topics of homicide investigations and criminal law. I have organized and hosted homicide conferences in Massachusetts and around the country. I have a Master's of Arts degree in criminology from UMass Lowell and a Bachelor of Arts degree in criminal justice / political science from Stonehill College. In addition to my assignment in the Division of Investigative Services, I have been assigned to the Division of Field Services, working in Troop C, Central Massachusetts, and Troop H, Metro Boston. Josh wants to know, how do the O'Keefes have a copy of this warrant? They said it was in a public filing in the criminal case. I don't think that we've ever seen it. Have we, Josh? 'Cause I don't remember seeing this. This was never in Karen Reed's criminal trial because this warrant was for a grand jury investigation for a case that was never indicted. Right? So, it was not part of the Karen Reed's criminal trial because this case there was no true bill returned by the grand jury. Scott McGinnis says Lieutenant Detective Tully has also been rehomed. No longer DA Meatball's detective group laterally transferred. Thank you, Josh, for your super chat. Huh. There was no true bill. Based upon information contained in the numbered paragraphs below, which are the product of my own investigation and my discussion with the Massachusetts State troopers involved in the investigation, I submit that I have probable cause to believe that evidence of a violation of Massachusetts general laws, witness interference, and a violation of conspiracy will be found on cell phones and or mobile digital devices used by Karen Reed. This application for search warrant is to seize devices only as described below. This is 31 pages long. I can't read the whole thing right now. My voice is going to shit. But hold on. Give me a second. Boy. They talk about Aidan Carney. They name episodes of Aidan's shows. We're going to need to do a separate show for this. Wow. Wow. I want to go back. Hold on. I want to go back because they say that this was public record and somebody will do a deep dive on this tonight. We need a show on this whole warrant. We do because we're all getting tired, but this is exhibit A. Let me just go back to where in the papers they talk about exhibit A. Oh man, this is some good stuff. Oh, wait. All right. Let's just search exhibit. I know I just read it. What page was it on? See exhibit A. Hold on. Here, let's go back to that footnote. Exhibit A is the affidavit of Detective Lieutenant Brian Tully of the Massachusetts State Police, dated January 22nd, 2024, which details his investigation in support of a search warrant issued for Karen Reed's cell phones pertaining to allegations of witness interference and conspiracy. This affidavit is part of an opposition filed by the Norfolk County DA in Reed's criminal matter, which was not under seal. Paper number 214. Plaintiffs acknowledge that Reed was not indicted for the aforementioned allegations. Well, I'm going to have to go back because I don't remember ever seeing this before. Does anybody? It says paper number 214. I'm going to find it. Is anybody surprised? Is anybody surprised? Do you think anybody has been working together? Do you think Tully has been working with any member of the O'Keefe family? Anyone? Karen says they're going to keep trying to find ways to burn her. Aren't they, though? Well, it seems that the Waterfall Bar and CF McCarthy's both joined in the motion. Karen Reed, it is Daniel O'Shea who is the judge on this. And I guess we're going to have to stay tuned, but we're going to need a whole entire show to just do that effort, to go over that search warrant. Strong Leg 1971, thanks for your 20. Their claim is contradictory. They claim Karen was extremely intoxicated, but sober enough to concoct a conspiracy and involve the niece to cover it. Can't have both. There's a lot of problems with it. That's just one. Thank you so much for your 20, for pointing out what we know is obvious. Cindy says, can you do bench trials in this case? Yes, you can. You can. Here's the other thing. And Massachusetts lawyers in the chat, you can correct me if I'm wrong. But here in New York, a case like this would be bifurcated, which means the first trial would be only on fault. Whose fault is this? They have to prove the accident happened and then determine fault. And then the second trial, second part of the bifurcation would be on injuries and proving the elements of damages and how much the injuries are worth. So I don't know if they bifurcate civil cases in Massachusetts, but I would submit to you that's the way it should be done. And the reason for that is because if the jury does not hear about the death and the tragedy of it all, they can make a decision, keeping emotion out of it. I mean, this is the rationale for it, about whose fault the accident was and whether, in fact, there even was an accident. And so they wouldn't hear all of the emotional testimony until after that was proven by the plaintiff that there actually was an accident. But yes, you can do a bench trial in a civil case. Thanks for your super chat. Bridget says, remember, Tully and Paul O'Keefe went to high school together. Conflict of interest, did they? I did not know that. I don't think I knew that. Josh says, how do the O'Keefes have a copy of this warrant? Well, that's exactly what I want to know, but they say it's in a public filing paper number 214. Now I got to go look because now Alice has to go down the rabbit hole. Tracy says, can insurance company decide to settle? They can. They can. Will they? I don't know. Alan Jackson and Eliza Little are coming to join the civil team for Karen. And you can expect some more fireworks. I don't remember when he made that announcement. Do you? Because this opposition was filed. The date on this is the date of service anyway. It was July 31st. I think his announcement that he was joining the civil team was before July 31st, was it? Paul and Tully played football together at college at Stonehill, says Mike. Thank you. I knew it was something to do with football, so it wasn't high school, it was Stonehill. They can. You do not need the defendant's consent to settle, but I just don't think there's going to be any settlement. I think Karen wants to clear her name, and I think that I don't think they're going to. I don't know. I don't think they will. Pierce says if Karen has a 1983 case and there are the same players in the civil case too, could this civil suit get stayed again? I don't think they wouldn't stay this wrongful death car accident case for a federal civil rights claim. No. Great question though. Thanks, Pierre. Jennifer Mulligan sends a super sticker. Thank you, Jennifer. Strong legs, 1971. I haven't commented in weeks, but know this, Melanie. I listen at work every day or after the live. I suffer from cupcake withdrawal when you aren't on. Best snark chat ever. Best legal insight on the tube. Thank you so very much for appreciating it. I appreciate each and every one of you because I know each and every one of you has very many places to watch your coverage. And you choose to spend your days with me, which I love and I appreciate so much. And so let me know your thoughts, questions, comments, and concerns before we wrap, because we're going to have to start a whole other show to go over Tully's affidavit that I've never seen before. Let me know if you have. Yeah, it's a long day. And we got cut off of that Zoom hearing earlier. Never settle with terrorists. A lot of people would agree with you on that. Thank you, Colleen. Melanie, on Karen Reed, if there was no crash report, is the insurance company responsible to pay out if guilty in the civil case? Well, there's no guilt in civil cases. It's negligence. It's liability in a civil case, but I'm getting what you are picking up, what you're laying down. If you're found liable in a civil case, yes, the insurance company is required to pay. They also have the option to settle. The thing is, let's say Karen's insurance policy is $1 million all in, right? And let's say the insurance company offers the $1 million and the O'Keefe say, no, we want 5 million. And the case goes to trial. They can never accept the $1 million from the insurance company and then go to trial and try and get more money. They have to, when you take money from an insurance company, you would have to sign a general release that would release the defendant, Karen Reed, from all claims. So I, as a plaintiff's attorney, would never look for excess of the defendant's policy limits. I would never do that. There are lawyers who would do that and get a judgment and then put a lien on someone's house. And that's just not my style. I would never do that. If the client wanted to do that, I would ask them to find another lawyer. So yeah, the insurance company would pay any judgment up to the policy limits. I hope that answers your question. Lois Lane, thank you for buying me a matcha latte and telling me that I make your day. You're amazing. Thank you, Ty. You're very generous, Venmo. Says Mel, great work. Appreciate the shout out last week. Thank you so much. Thank you so much, Ty from Massachusetts. I appreciate you more than you know. And Kara bought a matcha latte. Thank you, Kara. I'm going to need a lot of it today, tonight, tomorrow. We have Aiden's hearing at 2 p.m. The link to membership should be in the description below this video. Follow the Tully. We got to follow the Tully. You ever fall into those like Instagram? You ever fall into the Instagram like hard sell ads and you just like want to click on it to see what it's all about, like protein coffee, and then you have to give them your information and then they email you so much that you like block them for your email, except they keep using different email addresses to get through to try and get you to buy their protein coffee. Oh my God, I'm never doing that again. Don't do it. Don't do it. Don't fall into the Instagram rabbit hole of advertising. Gray Space says Tully's warrant is Exhibit B to the Commonwealth's opposition to the motion to disqualify the Norfolk County District Attorney's Office. But was it sealed or was it impounded, Gray Space? Thank you very much for looking that up for me. That saves me from the rabbit hole of hell. And Bridget said, I thought it was high school, but could that be conflict of interest, them being friends? Tully and Paul O'Keefe. I don't think so, because Paul O'Keefe is not a potential suspect, right? There would be a conflict where they were investigating someone that they had a relationship with who could be considered a potential suspect and or a witness, right? And Paul O'Keefe really wasn't a witness to anything. So as much as I would like to say conflict, I don't think it is a conflict. If anybody disagrees with me, be sure and let me know. I know you will. All right, everyone, we are going to be back here tomorrow for the 2 p.m. hearing on Aiden. If I can put something together to do about this Tully stuff, but I have things to do in the morning, so I don't know. if I can, but I will. But you want to make sure you're subscribed. You want to make sure you hit the like button. You want to make sure you have all notifications enabled on your phone and whatever device it is that you're on, so that you will know in case something pops up. You will know if I go live. And so then there's that. Oh, Jody says, AJ made the announcement a week ago, August 3rd or 4th. Thank you. So it was after the plaintiff served these papers upon the defense. Okay. All right, my friends, stay safe out there. Stay cool, stay kind, stay classy. Thanks to the moderators. It's a long day and you guys are amazing. And I love you for all of the work that you do. For each and every one of you who choose to spend your days with me, I appreciate you so very much, more than you know. Thanks for Sheila for becoming a member. Stay cool, stay kind, stay classy. Until tomorrow, I know you can do it. I know you can do it. Peace out, my friends. I'll see you tomorrow.